Good evening, everybody. And I'm talking also to the people lucky enough to receive this on Zoom. I'm sorry the picture is not great, but I hope you can hear me. I'm Guy Sandhurst, as most of you know, Chair of Research for the Society. Welcome to this hybrid meeting, because as I said, we've got attendees both in person and by Zoom. I'm pleased to welcome, particularly tonight, His Excellency Magzan Iasov, who is the relatively new Kazakhstan ambassador to the United Kingdom. It's a great privilege to have you here, Ambassador. We're going to hear tonight about two interesting and significant tribunals which were established in 2018 in Kazakhstan. These are the new Commercial Court, that's the AIFC Court, and the International Arbitration Centre. Lord Woolf, who's here tonight, but who's off screen at the moment, was the moving spirit. But he's here to listen, and I think we might hear a few words from him at the very end. Christopher Campbell-Holt, an English barrister by training, is the Registrar and the Chief Executive of the two institutions and the enforcement judge of the court. He was previously Registrar of a similar court in Qatar under the presidency of Lord Woolf. Lord Faulks, King's Counsel, who will be well known to you all as a distinguished practitioner in this jurisdiction, a life peer and a minister in the coalition government, is a justice of the AIFC Court, and we will hear from him after we've heard from Christopher. Finally, we will hear from Professor Marc from University College London, who is Chair in Corporate and Financial Law at that university, and has lectured widely on international commercial law in Kazakhstan. I anticipate that we will hear from the panel of the attractions which the English common law offers to international players around the world, and what an opportunity there is for those proud to uphold our traditions, to market them, and to strengthen the United Kingdom's trade and invisible earnings, and bring benefits to countries around the world, particularly those which are not so big and powerful. These two courts, together with the Qatar court, show how the English common law systems of justice increasingly have appeal to other jurisdictions who are looking to enter the market, and that the export of the rule of law can assist emerging markets to become successful commercial centers. What is going to happen now after that introduction is that Christopher Campbell-Holt is going to come and sit where I am, rather than me moving the camera round to him.
Well, thank you very much indeed, Lord Sandhurst, for hosting us today with the Society for Conservative Lawyers. May I also thank Sherry Clark for organising everything for us and supporting us so kindly. Lord Faulks and Professor Marc, thank you for your support of this project and of our efforts this evening. And with great respect to the new Kazakhstan ambassador, Magzan Ilyasov. May I thank Lord Woolf very quickly for being with us as well. And I've been incredibly fortunate for nearly 20 years of my legal career that Lord Woolf has been my mentor. And we've worked together in Qatar on a similar project, and now recently, in recent years, Kazakhstan, which is the main focus of our discussion this evening. Just by way of a quick introduction, in the limited amount of time we have before I think others speak and we take some questions, I want to set out our example as a case study, if you like, from Kazakhstan. What Lord Woolf and myself and the governor of the AIFC, Dr. Karak Kalembatov, and others did with the full support of the president of Kazakhstan was build what I think we can say now was a truly special common law procedural-based commercial court for investment and business disputes. In addition, we established an international arbitration centre, which has for the last 5 years been chaired by Dohmann KC from Blackstone Chambers in London. And put those two together, what you have is a unique offering of world-class dispute resolution for investors already in Kazakhstan, investors in the region of Eurasia, and more globally, but specifically with some nexus or connection to Kazakhstan. The topic is soft power. I'm never really sure what one means by soft power. It's something which I hear a lot in Kazakhstan, particularly with embassies and business delegations that come to visit us at our facilities in Astana, the capital city of Kazakhstan. But I'm not quite sure what it means. So I want to define it in my humble way, if I may, for the purpose of today's discussion, at least for what I'm about to say anyway. And that is soft power from the perspective of our project in Kazakhstan, in Qatar and other parts of the world is really about direct, not indirect, but in my view, direct influence, making a positive contribution. Oh, sorry. I'm just, all right. Making a positive direct contribution to investment attractiveness to a country, whether it's in Qatar, Dubai, Abu Dhabi, Kazakhstan, South America, China, right, wherever. It's the same thing ultimately. And what that requires is absolute support and leadership from the countries. So typically from the president or the most senior leaders of the host country. And we're all there at the invitation of the leadership of that country. We're not there to educate or to inform or anything like that. There's no degree of superiority whatsoever. This is an invitation to come to a country, in our experience recently, a frontier or an emerging economy, to contribute as one part of the future success story of that country, to radically modernize its court procedures, its legal infrastructure, and ultimately to build absolute trust and confidence in the investment communities coming to the country, but hopefully coming to the country in the future on a sustainable basis as well. So that is how I see soft power in action through our project in Kazakhstan and in other parts of the world through these types of dispute resolution, English common law courts around the world. Is it an export? The title also says soft power exporting the rule of law. Well, absolutely, yes, I think it is. There's no mistake that the AIFC Court, the Astana International Financial Center Court in Kazakhstan, has a bench comprising English and Welsh highly experienced and regarded judges. And this is critically important for many reasons. Again, trust and confidence, familiarity, respect of the business community. These are judges who come with unprecedented experience and credibility and are immediately recognized and trusted by investors coming to countries like Kazakhstan. The common law, I won't say too much about that. We all know better than anyone what the common law is and how it operates in practice. But it is immediately attractive to investors who are already experienced at investing in other common law jurisdictions or other civil law jurisdictions where the parties have managed to apply a degree of common law in their business contracts. The law is flexible. It is able to respond in various ways, specifically through the judicial process, to the ever-changing needs of businesses. And our court rules at the AIFC Court, which Lord Woolf drafted some years ago when we first established the court, are written in a flexible way so that the facility is already and always immediately responsive to changing business and legal needs. I want to just very quickly in the time I have give an example of how this can be successful. I've said at a very high level in the time I have what it is, why it's there, and how it comes to happen by the leadership of a host country. But the AIFC already claims in less than 5 years of operations to have attracted more than $7 billion of new investments into Kazakhstan. And we hear from feedback from users in the wider Eurasia community that our court is one of the key reasons for attracting that investment, because it has provided, as I've said a few times already, an immediately recognizable and attractive and reliable and trustworthy dispute resolution mechanism to show investors that if they have problems, which investors do in their everyday businesses, their rights, their legal rights will be protected with absolute independence, impartiality, above all, incorruptibility, applying the very highest international standards, English standards of the rule of law. The topic is also about commercial opportunities. Well, there's no shortfall of opportunities, commercial opportunities for lawyers and businesses and investors created, if you like, by a new financial center and specifically by an English common law procedural style international commercial law court. The evidence so far has been that our court has successfully resolved and given 45 judgments within 5 years of operations. Now, that doesn't sound like a huge volume of casework, but it is. No other court in a financial centre like ours has delivered that many judgments. About 10 to 12 cases of judgments would be typical for the very best before we were able to establish our court in Kazakhstan. We have opt-in jurisdiction. Very important to build that accessibility to the court. So essentially, any investment party or business can simply write into a contract or any other agreement for the court to have jurisdiction. Of course, if a law prohibits that from happening, then that's not possible. But this has enabled us to be immediately attractive to investors. And it is another example of how an English-style procedural common law commercial court can be relied upon immediately, not in 5 or 10 years' time, but right now, from the very beginning of its operations, to good effect. So the obvious advantage from a commercial perspective of a court like ours in Kazakhstan, in Qatar and other countries, is its immediate and future attractiveness and impact on bringing more investment into a country like Kazakhstan. But there are far wider commercial benefits that a court like ours can and frankly is already providing. We have contributed again at the invitation of the Supreme Court of Kazakhstan to assisting with legislative drafting of the Civil Procedure Code in Kazakhstan. We've done this at the invitation of the Chairman of the Supreme Court of Kazakhstan. We are completely independent of each other, but we cooperate because we recognize the importance of working together for the benefit of our project and the overall judicial system of Kazakhstan. So our English common law court is already having a positive impact on the development of the national judicial system of the wider country of Kazakhstan, and if I may add, wider throughout the Eurasia region, because other countries are watching very closely with what we are doing. The other benefits are education. We have a shining light in the room with us today, Zhania Orezbekova, who is one of our brightest, youngest Kazakh national law students. Now, she's just graduated high school. We've had more than 100 Kazakh national law students come through our internship program. And Zhania is a leading example of the future of Kazakhstan and lawyers in the community. She's currently at King's College London studying for her LLB law studies. And there are many other examples of that positive impact that a court like ours, soft power exporting the rule of law, can bring to a country like Kazakhstan. Now, very quickly, we're not alone. Kazakhstan, I think, provides a brilliant example, an up-to-date modern example. Similar courts have been in existence in the Middle East, at Lord Woolf's court in Qatar, at Dubai and Abu Dhabi and others for some time. But I've tried to establish in the time I've had now to establish how ours is truly special for Eurasia, because it is the only type of English common law court that exists in the entire Eurasia space. There are other countries jumping on top of this. Cambodia, Vietnam, South America, they are all working hard to develop similar English-inspired commercial international courts. So the contribution that is being made and can be made is immense. I will draw to a close my opening remarks. Thank you very much.
Thank you very much. That was a very helpful overview. I'm going to ask Lord Faulks now to carry on. Lord Faulks, as you recall, sits as a judge, as a justice in this court.
Good evening, my lords, Your Excellency, ladies and gentlemen. I come to this from a slightly different angle from that you've heard of from Christopher Campbell-Holt. Some of you may remember that in 2015, there was a global law summit in London. This was to commemorate Magna Carta. And as a then minister in the government, I was given the task of going around the world, inviting leading figures in their respective countries to come and participate in the global law summit. I went, for example, to China, Hong Kong, Kyrgyzstan, and Kazakhstan. I went to Almaty and Astana. And I have to say that I was met with considerable enthusiasm in Kazakhstan. I spoke to the then Prime Minister and invited him to come to the Global Law Summit in London. Not only did he accept the invitation, but he made a speech at the inaugural meeting, which took place in the Queen Elizabeth Hall, and made it clear that Kazakhstan had a commitment to the rule of law. And I think a number of people didn't know all that much about Kazakhstan and were impressed by the fact that here was an obvious exhibition of the country's keenness to show that it was adopting or was prepared to adopt many Western standards in its approach to legal disputes. It was therefore a happy coincidence when Lord Woolf approached me and asked me to be considered as one of the judges in the panel court that was being set up in Astana. And after the governor had interviewed me together with Lord Woolf, I was honoured to accept that role. Christopher has told you about what the court does, the fact that it's there is an opt-in jurisdiction, that it has an increasing number of cases. And I can give recent evidence of that, having sat only a few weeks ago in a case in Astana. It was a remarkable technical achievement, apart from anything else. One of the advocates was in Beijing at the time when advancing the case. The languages included Kazakh, Bulgarian, and Russian. Contemporary interpretation at the time. When people got excited, it did sound a little bit like the Tower of Babel, but we got there in the end, I think. The technical achievement was considerable, and I only hope that I came to the right conclusion. Also, I've had the privilege of determining a dispute between a Russian company and a Kazakh company. Just to give you an idea of the range of the disputes. As Christopher quite rightly says, the court is much admired. The rules, I see that Christopher's taken away a copy of the rules, are pretty straightforward and well understood, modeled as they are. I have now a copy of them. Modeled as they are, loosely but helpfully on the CPR, with which we're extremely familiar in this country. They have proved helpful, although in an attempt to try and encourage users, not necessarily familiar, we haven't been too rigorous in sticking to the letter, providing the spirit of those rules is encouraged, certainly in the few interlocutory hearings I've had. And the culture is slightly different, of course, in Kazakhstan, and the approach of the advocates so far has been not entirely congruent with ours. But in many ways, it's a work in progress, but I think a work that's progressing very well. I've also noticed that there is considerable interest throughout Eurasia in similar courts being set up. I think it's fair to say that the AIFC is something to be envied in that area. And Christopher, I'm sure, is too modest to say that he's been receiving blandishments to go elsewhere and establish something similar. But it does, of course, require an enormous amount of cooperation and trust and a phenomenal amount of work, which is provided by an extremely talented staff with whom Christopher works. And the progress is getting better with the opt-in jurisdiction. The arbitration procedure is going extremely well. There are many arbitration cases at the same time as the court hearings. Are there lessons to be learned generally? I think there are, in the sense that we should not get too misty-eyed about what we can tell the world. We aren't telling the world anything, but we do have a good model here, which is much admired. The quality of our judges, I hope I can say that, and the rule of law is something that is an export, I think, whether it's called soft power or not, which is much appreciated throughout the world. And for advocates, it can remain an attractive possibility. Rights of audience in the court in Astana are fairly, I wouldn't say loosely applied, but we are understanding the fact that people may have come with different experience. And we hope that by enabling advocates to gain experience, they will become more and more familiar and more used to appearing. And indeed, I think there have been some regular frequent appearance from various advocates who are obviously getting the trust of the court and the trust of the litigants whom they represent. So I think this is a very positive step. It was a brave thing for Lord Woolf and Christopher to to set up. I think it's been a success. It could be mirrored elsewhere. And I think there are some real opportunities for advocates and for lawyers generally in mirroring this elsewhere other than the classic stuff. Thank you very much.
Thank you very much, Edward. That was very helpful. I think we'll now bring Professor Marc Moret into the camera, and he will see it from a sort of English academic perspective, and then we'll open up to questions.
The irony is not lost that I'm actually a Scottish academic, but in work terms, I'm an English academic in work terms. But good evening, everyone. Good evening, Your Excellency. Unlike Lord Faulks, I've not sat on the AIFC Court, but I have spent quite a bit of time in the AIFC Court in Astana, now Nur Sultan, and I've worked quite closely with the Kazakh legal community, running a series of training sessions on the AIFC regulatory system and also on common law method generally. So I've got quite familiar with many members of the Kazakh legal community. Before the pandemic, I ran training sessions at the AIFC Court and also at other locations in Nur Sultan. And also, it's now gone back to Astana, hasn't it? Yeah, yeah, sorry, Astana. And also in Almaty as well. And then obviously after the pandemic, we've been continuing those sessions online virtually. I've had a lot of interactions with members of the Kazakh legal community, predominantly young, enthusiastic Kazakh lawyers, either who work in the government realm in Astana or who work in more commercial activities in Almaty. And I've also had a lot of follow-up conversations with a lot of young lawyers who've been quite keen to learn more off their own back. So there's been huge enthusiasm. There's been a real eagerness to embrace these, for want of a better word, foreign norms and ideas. And what's quite curious is when I first started working with Kazakh lawyers, I thought I'll be dealing with a lot of lawyers that, you know, international commercial law practitioners that want to get involved in the AIFC Court. The things they'll be really keen to learn about will be, you know, really kind of practitioner transactional stuff. Contract clauses, indemnities, MAC clauses, force majeure, all these things. Actually, the stuff they really liked was the really academic stuff that we teach to our undergraduate students. So they were quite happy they could happily spend hours talking about Victorian case law on concert halls that burned down and whether the contract's frustrated. And I thought it was great to see not just an instrumental interest, but a real genuine academic interest in the law as well on the part of these practitioners. So that was a really great thing to see. But what was also really refreshing to see was young, not just young, but predominantly young Kazakh lawyers are really keen to learn common law ideas, but also they are very keen to absorb them into their own domestic legal work as another part of their toolkit, as both a domestic Kazakh lawyer and in due course as an AIFC lawyer as well. So that was really refreshing to see. There's certainly opportunities for English lawyers to work in courts like the AIFC Court. The one thing I would say is at the same time, it is extremely important to ensure that the domestic legal community in Kazakhstan are enfranchised in the process and do feel like active participants in this process. And I think, you know, that's a win-win scenario, I think, for both sides. I think enfranchising and involving the domestic Kazakh legal community, I think, goes hand in hand with creating opportunities for English-based lawyers, I think, to be involved in the system. There's very much a synergy there. So that's something that's been really encouraging to see, and I very much hope and expect that that trend will continue. I mean, a couple of other sort of questions, issues related to that. I mean, intuitively to some people, this idea seems quite strange, that you can have a court applying the law of another geographic jurisdiction in another country. Now, there's many things that the AIFC does that makes it unique as an institution, but I think it's actually a part of a kind of broader historic trajectory. The idea that courts will decide disputes involving parties from other geographic locations is not new at all. The English courts are not really English courts, they're global courts to a large extent. I think last statistic I read said roughly 50% of litigants before English courts are non-UK parties. So from this, the idea of global courts in that sense is it's part of a bigger trajectory. And also, I mean, for example, in the United States, the Delaware courts have been deciding disputes by parties outside their jurisdiction for over 100 years. We now see a similar trend with countries like, for example, British Virgin Islands and Cayman Islands now becoming dominant jurisdictions for US-listed Chinese companies. So there's a kind of broader historical kind of trajectory going on here. And in that regard, I would say, well, there's a lot of unique things the AIFC Court and Arbitration Centre are doing that very much mark them out as distinct. The AIFC, in many ways, is part of the evolving norm rather than the exception. And I do think that in due course, the idea that commercial disputes between in business-to-business transactions, the idea that these disputes need to be resolved by domestic courts within the geographic location, I think that's becoming an increasingly anachronistic notion now. And just final comment about common law. I mean, what marks a common law court out for this sort of international commercial activity? I think obviously things that readily come to mind, I think to many common lawyers, the stability and predictability of the common law system is one thing. I think the dual complexity and simplicity of common law makes it something that's readily transportable to other legal cultures. The idea that you have what are quite simple, straightforward legal principles, but on account of their flexibility can apply to a whole range of complex transactions that were never envisaged when the principles were developed. And I think that does mark it out for these sorts of institutions. And also the final point I'll make is, I think one of the other real attractions of the common law, and something that comes out in a lot of certainly conservative understandings of the common law, is the idea that the common law is a non-intrusive form of law. The common law, by its very nature, does not seek to superimpose norms on social or economic activity, at least when it can avoid doing so. The common law is endogenous. It tries to consolidate and entrench pre-existing commercial norms as best as possible. Not just pre-existing commercial norms, but related norms of commercial fairness and morality as well. And I think that's really critical, especially when we're thinking of, to go back to the point Chris made, institutions like the AIFC, which coexist with domestic courts and other legal institutions in Kazakhstan. It's critical, I think, that that AIFC law and also domestic Kazakh law are able to coexist in a harmonious way. And I think the nature of the AIFC as a common law court, I think, positions it very well to do that. So my final concluding comment really is, I think this is a positive development. It's an exciting development. And I think that synergy between the domestic legal community and also the English law community is something that needs to be nurtured as best as possible in order to maximize these benefits. So thank you.
Thank you very much, Marc. What I'd like to do now is I'd like to ask the panel is, I think it would be helpful for all of us who know nothing about this court until today or until recently, to understand by way of a sort of simple worked example of a real case which has taken place is really who the parties were in terms of what sort of country, what sort of business they did, and how did they come to give jurisdiction to the court? Was it just that when the dispute arose, they said, well, let's give it to this court to resolve it? Or was it written into the contract, which was the subject, had given rise to the dispute? What law was applied? Because you talk about the common law. Is this just straightforward borrowing from the English commercial court? Or is it developing Kazakhstan court norms? How long did the case take from the time that someone issued proceedings to getting judgment? So first question is, who were the parties, so to speak, and what was the nature of the dispute? Who would like to deal with those? Edward? Right. Lord Faulks.
Okay, well, I'll deal with a particular case, and then extrapolating from that, Chris may be able to give a wider view to other similar cases. The case I just dealt with involved a joint venture between a Bulgarian mining company and a Kazakh company with experience in mining, in particular had their contacts in Kazakhstan in various potential mining fields. The basis of the dispute was an agreement, an agency agreement as it was described, and what it came down to was what did the agreement actually say? And did events mean that the terms of the agreement resulted in agency fees being generated, or did they not? As to the jurisdiction, there was a plain reference to the jurisdiction of the court. There wasn't any issue on jurisdiction, and it was English law, although, as Guy said, sometimes there will be Kazakh law, so there may be some contest as to what the law is, either from experts or agreement between the parties to the principles to be applied. The other case that I had recently involved a Russian company and a Kazakh company. It was a major dispute about monies owing on the construction of an unmanned space station and the failure to do an environmental assessment. There was a jurisdiction clause, plainly giving jurisdiction court, the AIFC court. However, the difficulty was that the contract provided that the dispute should be heard in Russian, whereas the court provides that the dispute had to take place in English. The Russian company argued, therefore, that we did not have jurisdiction. So there will be disputes, I suspect, as there quite often are, I gather from Qatar and others, as to whether we had jurisdiction. I concluded that we did have jurisdiction for reasons I won't weary you with. Those are typical cases, but Chris may be able to extrapolate further.
Thank you very much, Lord Faulks. Just to add to that, from a general perspective, we're seeing all manner of commercial disputes now coming through both our commercial court and our separate independent international arbitration centre. I would say in all of the cases so far, and we've successfully resolved more than 1,500 cases now across the court in the arbitration centre in less than 5 years. The court or arbitration centre are specifically provided in a contract. Now, what has been interesting has been that some of these contracts were in existence before we even began our operations in January 2018, and the parties have amended those contracts specifically to include our court and arbitration centre in those contracts. So the court and arbitration centre are regularly dealing with such disputes. I think that says a lot for the project in the country of Kazakhstan, that parties are proactively doing that themselves. So really, it's contracts is where people tend to find the jurisdiction on the opt-in consensual basis to use our court or arbitration centre. The other main way is transfer of cases. Last year, we developed and launched a transfer of cases scheme with the Supreme Court of Kazakhstan. This required years of negotiations and hard work, but we got there and received nothing but total support, albeit independently, of the independent Supreme Court of Kazakhstan. And we've now successfully at the AIFC Court resolved, I think, 3 cases that have been transferred to us out of the 45 judgments that have been given. And our Chief Justice, new Chief Justice, our first Chief Justice, as he learnt earlier, was Lord Woolf, the creator of the AIFC Court, but now the Chief Justice is Lord Mance, the former Deputy President of the UK Supreme Court. And he has given jurisdiction in those 3 cases on a transfer basis. And the way it works is the parties have to consent in writing. So they make an initial civil or commercial application to the national courts of Kazakhstan. For whatever reason, they change their mind and they decide, no, actually, I'd like to go to the AIFC Court or to the International Arbitration Centre. And then they come to us, we have a discussion, they complete a consent form. It then goes to, the consent form goes to our Chief Justice, Lord Mance, who makes a decision whether the court will have jurisdiction, or to the IAC Chairman, Dohmann KC, whether the IAC will take it on. And if they do agree and give an order or a letter to support that, then that is what happens. We go through the normal process. So that's the second main way that the court and the arbitration centre are securing work. The parties typically, we've done a statistical analysis on this, and out of more than 1,500 resolved cases, in 48% of those cases, the parties were not Kazakh. The parties have come from 21 different countries. So we really are attracting international business with international people. The types of disputes, Lord Faulks has just given some practical examples from his experience as a judge at the AIFC Court, but it's typically non-payment under contractual arrangements. We're increasingly receiving very high value construction law disputes, road building schemes, hotels and the like in Kazakhstan and the wider Eurasia region, property claims, finance, banking, even AIFC related employment disputes. The parties typically speak Russian, not English, which is interesting because the judges all speak English, not Russian. And we have simultaneous translation provided in the court and in the arbitration centre. It works seamlessly. I think that's been our experience so far. No complaints from the parties. And we've built a culture of expectation now that the court and the arbitration centre will successfully resolve disputes one way or the other very quickly. Very quickly for us does not mean within 2 months, perhaps, as it is by law in the national courts of Kazakhstan without fail. Exceptionally 3 months or so with an automatic right of appeal. For us, it can be 6 months, or it can be as little as a few days if we get urgent interim applications, which we do receive. We have an emergency procedure both for arbitration and the court, which helps us to deal very swiftly indeed with disputes online. So overall, I hope that provides a useful introduction to the types of cases that we're getting and how we're operating to get the job done quickly and cost effective.
I'm interested in how the law is developing. In other words, is it essentially sort of commercial court law, but then people say, well, actually in Kazakhstan or in Bulgaria, we've always done things this way. I mean, that would also be common law, wouldn't it? I mean, how is it happening? Do you want to talk about that, or
yeah,
Marc?
I mean, what I've found interesting and getting to grips with AIFC law is that I mean, obviously it's AIFC's law is rooted in English law. It's rooted in the common law, but quite uniquely, there are actually a set of regulations, not just procedural rules, but also substantive law as well, has been codified in areas where it's not actually been codified in England. So, for example, the AIFC contract regulations actually seek to codify a lot of mainstream elements of English contract law. AIFC companies regulations are actually quite a bit different from the UK Companies Act. So there are a lot of subtle differences. What I'm interested in, and I guess it's unhelpfully probably more a question than another question and an answer, but where you've got almost in many ways quite a distinctive set of common law-based rules in this jurisdiction, will we see cases kind of follow their own trajectory? Will we see for example, local Eurasian commercial norms have more of an effect on AIFC decisions than would be the case in an English court in London? And it's quite an exciting development. From an academic's point of view, that's a really exciting development that could happen. And I guess probably it's people like Lord Faulks that would be the best people to answer that question who are actually making these decisions. But
I think as historians are prone to say, it's probably too early to say because there haven't been quite enough judgments, and we're seeing how things develop. You're quite right about the contract regulations. I mean, I think that, albeit that this is English law that's being applied by English lawyers, it never applies law in a vacuum. You will take into account the particular circumstances of the case, which will involve an understanding of the way companies, international or national, are functioning. And that may give a particular flavor to the cases. We have actually discussed amongst the judges the extent to which we may be setting up, as it were, a new precedents. Yeah. And I suspect there may be certain practices, I mean, good practices, I hope, that will be distinctive to the court. I wouldn't have thought there would be a massive deviation from the common law, but there may be a modification or acceptance of the particularities that the local climate requires.
I mean, in turn, could it work the other way in due course? Could a court in London draw on an AIFC decision?
Well, I mean, we know that the higher courts here are quite persuadable that there is wisdom to be found outside the courts here. And particularly if it's been given by judges steeped in common law and it's on an area where possibly a judgment on something that hasn't been decided upon previously, I can't see why it wouldn't contribute to the thinking and would be cited at Supreme Court or Court of Appeal level if it was helpful. Yes.
Please do. Of course. Thank you. Just to add to what's already been said, if I may, the court, despite giving 45 judgments, it is already setting precedent. And there's one particular area, but it's mostly on procedural points of law, and that is amalgamation of cases. So companies that have been previously registered within the state of Kazakhstan are now increasingly looking to move those assets within the new international financial center, the AIFC, in Astana, Kazakhstan. And to do so, they need to comply with various regulations, one of them being the AIFC companies regulations, which are modelled, although as Professor Moore said, are quite different from English companies law. And there are specific procedural requirements. And the court, our AIFC court, has already decided in about 6 judgments how those procedural points should be addressed. And we've already got senior judges quoting other senior judges from our own courts on how things should be done better next time. And so that is one obvious immediate example of how it's working. I wanted to add, though, although we have a superb codified common law principle-based international commercial law system in Kazakhstan, in the AIFC, which is separate from the national civil law legal system. In most of the cases that we've dealt with, out of 1,500 plus across the court and arbitration system, they've applied Kazakh or Russian law. And we've got English-speaking common law judges, but with profound international experience as arbitrators, mediators, judges elsewhere, and so forth, and advocates, applying civil code of Kazakhstan in the English language with the assistance of notarized documents and simultaneous oral translation, and making points of law that will then be applicable and will be supported by decisions of judges in the national courts of Kazakhstan. And I think that is quite unusual as a result of our project. And I'm seeing that as a registrar of the court on a frequent basis through our dialogue with the national court judges, who tell us, well, you gave a judgment at the AIFC court on this, we're going to consider that in our decision-making process in this way. So I think that's a very useful development and another example, positive example, of the export of an English common law court like ours in Kazakhstan.
Does anyone sitting over there, in other words, off camera, have a question they'd like to ask? Yes, do. This is Sir Bob Neal, who chairs the Justice Committee in the House of Commons.
What about this?
For anyone who didn't hear, the question is how are these things enforced? Yes,
thank you very much, Sir Bob. So when Lord Woolf set up the court, if I may say this, in Lord Woolf's presence, enforcement was one of, obviously, for obvious reasons, one of the key factors that we considered from the very beginning. Now, we're all probably aware of other similar courts or arbitration centres who unfortunately have not had that thought until very later in the stage of their development. I won't name them, but there's one or two in the Middle East that come to mind immediately for me. So we dealt with this immediately. And what we did was develop a special step-by-step procedure for enforcement of our court judgments throughout the entire territory of Kazakhstan. To start with, people were saying, oh, you can only enforce in Astana, the capital, oh, in the commercial centre of Almaty. No, it's the entire territory of Kazakhstan, which is roughly the size geographically of Western Europe. We have enforced this on a regular basis. So we've got the Minister of Justice of Kazakhstan has signed an escalation procedure if we need it for enforcement against state assets. I said earlier in my remarks that the state of Kazakhstan, I think, has lost, I think it did, 3 cases. And the state of Kazakhstan has paid every Kazakhstan tenge to about $4.5 million across 3 cases to enforce. And so the state at the highest level understands the central importance of not just of paying up when they lose, but recognizing that and promoting that as a positive indication that this is a serious place now to come and do business. And if you win a case at the AIFC Court or the arbitration, you will get the payment or the enforcement required under enforcement as quickly as possible. So this has all been done, 100% satisfaction of the parties, and we check, including the money going from one account to the other, to check that parties are receiving the money due under a judgment. It has been, I think, uniquely 100% so far. And that's because we put a special procedure in place. It requires procedure, it requires relationships as well. And this is something which is critically important to any project like ours, promoting the export of the English common law. You've got to have those day-to-day working relationships with the people to make it happen.
I mean, I haven't got an answer to that question. I don't know is the answer. And I mean, I can see that at this particular moment, enforcement could be challenging in that particular circumstance. And I'm not sure, or Chris will correct me if I'm wrong, that any of the arrangements are necessarily going to solve that particular problem. But perhaps you can correct me. Yes, well,
thank you, Lord Faulks. Not correct, just maybe. Obviously, we've thought about this. Russia is a tricky place for lots of reasons. I'm not going to comment on that. But what I can tell you is that specifically within the Eurasia region, Uzbekistan, Kyrgyzstan, and other countries, we are working face-to-face with chief justices and ministers of justice in those countries to agree competent court status of our AIFC court under international treaties between the state of Kazakhstan and those countries. And so far, we've been told that we do qualify as a competent court. That has been explained to me personally, face-to-face, by the Chief Justice of the Kyrgyzstan Republic courts. We've signed an MOU with them recently, and they are going to publicly say on record that not only this, we are a competent court, but we will enforce if we get AIFC court judgments. So we've done a lot of progress, but there's more we can do, obviously, in other countries. But that's an example of how it can work outside of Kazakhstan for enforcement.
Question over there. Can you just shout your question and I'll do my best to repeat it? The question for anyone who couldn't hear it at the other end of this line is costs orders. How do they work? Are they enforceable? And what are the sort of, how are they sorted out? Who decides what order of costs there should be and what basis?
Essentially, the same principle applies as in English law. You know, generally speaking, the winner gets their costs and the loser pays costs. Of course, there are powers to vary the costs order to reflect particular demands, and costs would be enforced together with a judgment exactly the same way that Chris applies. So there's no sort of special or unusual arrangement.
May I add that the Kazakhstan National Court System procedural, this is called the Civil Procedure Code, actually has a very similar system for costs that we have in the AIFC Court and in the English and Welsh system. So this is not something we've hugely contributed yet to Kazakhstan, because I think, frankly, it was already there. But that's not necessarily the case in other countries which do have similar courts to ours.
You have to, if you can stand up and shout, because we've got.
My question is, would something like this work in the less advanced European Union countries? Do you think there would be an impossible to Parliament? How possible would it be?
You can, if you, whoever's going to answer it can repeat the question they're answering.
My apologies for hogging the. I think the question is about how would this project work or similar project work within the EU, right? If it was not just for enforcement, but to set something up. Well, in various countries in the EU, similar courts are already coming up, but in a different way. So Germany, I think it's Frankfurt, now has a commercial court which is drawing upon common law principle. I think speaking the English language. I think in Amsterdam or The Hague, there's a similar court. In France, there's now a similar court. So other countries, I should say countries within the European Union, are adapting their models to suit themselves, of course, and their business interests, but are applying a more international commercial law concept in some ways similar to what we're doing, in other ways very different. So it's not unique. The European Union does have and is having now some courts, and some of those courts are speaking English language, when that's obviously not the national language of the country.
Any more questions? Yes.
Yes, I think that's true. I mean, the fact is that the cases come on very quickly compared with, say, in the commercial court here. And I'm not disparaging the commercial court here. One of the reasons is because the court is relatively in its infancy. There is the capacity. There are the judges. And I know that the case that I gave judgment, came to judgment very swiftly. There was one interlocutory hearing. Actually, there may have been two, which we refined what was needed. And the hearing took 1.5 days as a result of cutting down what was actually needed. And the submissions weren't at great length, actually, and marked contradistinction, sometimes the case in English courts. So I think there's quite a lot of reasons why you might consider it, at least.
May I just add very briefly, and people are. So we know from just talking to the senior lawyers on our court and arbitration center users committees that our court and arbitration center have been included in their client contracts of a minimum of 7,000 business contracts. And that's obviously going up all the time. And these are big companies like Shell, NCOC, for long-term soil use contracts of 20 to 25 years as an option. It is operations contracts of 3 to 5 years duration with renewable options. So we're already going to those contracts precisely for those reasons. We're in Kazakhstan. Businesses don't have to travel and have all the unnecessary costs associated with it, and we can do things quicker. And if that doesn't work, we can do it online as well. So we're already going to those contracts. So I would urge you and your clients to seriously consider maybe doing the same.
Well, ladies and gentlemen, I think we've done pretty well. What I was going to do now is hand this over with the camera, I hope facing Lord Woolf, to make a few closing remarks. Yeah?
I've enjoyed listening to what is being said on all sides in this very inspirational meeting. And I feel it's very much part of the process of development of the court in Kazakhstan that this meeting should be taking place. And I want to congratulate everybody involved on the excellent way they've explained the issues that arise with a new court in a different jurisdiction from our own in the UK, and how matters are progressing. And I think it's going to be very exciting indeed to see how the process continues. What is here an isolated example in relation to one country, I think has every prospect of being repeated around the world and being used so as to bring together parties so they can have their disputes settled by court where necessary. The parties are unable to do that themselves. So I congratulate all involved on, first of all, thinking of the idea of having a meeting here in the court, the Parliament of the United Kingdom, and secondly, on what they had to say to us. Well done.
I'll bring it to a close then. Thank you very much, Lord Woolf. And I will just, for those who aren't here, but who may not have guessed it, we're actually sitting in Committee Room 1 of the House of Lords, which is one of the rooms where the appellate committee, the Judicial Committee of the House of Lords used to sit. And I can say that the meeting will go up on our YouTube channel in before too long, so you'll be able to watch a recording of this event. those of you who want to be able to tell your friends they can watch it, even if they're not suffering from insomnia, says me rather rudely. But seriously, I think it has been very interesting. It shows great potential for the UK and for other jurisdictions who want to develop sound commercial practice and encourage trade, because we all know that people like to trade somewhere where they know that if things go wrong, they can have fair and effective justice. So thank you very much. On that note, I think we'll close it down. Goodbye.